My name is Terry Dietsch. I'm a senior judge, Vandenberg Superior Court. I graduated from law school at University of Indiana, Bloomington in 1959. So this is year number 50 for me. I started with the law firm of Bamberger, Foreman, Oswald, and Holland. At that time, the law firm consisted of Fred Bamberger, William Foreman, Charles Oswald, and Robert Hahn, and I was the only associate. It was a very interesting experience. At that time, the law firm practiced extensively, not only in Evansville, Vandenberg County, and federal court, but also in the outlying county, Posey, Warwick, Gibson, Spencer, Perry. And we had a lot of cases in those out counties. So as the young person, the only associate, I found myself doing a lot of traveling to the out counties and preliminary work, arguing motions, setting trial dates, once in a while maybe a small trial. And I found rather quickly that, in a sense, at that time, we sort of dominated the calendars, the trial calendars in these various counties. And I would go up to meet someone to set a trial, and they would raise Cain about when this case could get tried, and I would tell them when we had an available date, and they would say that's too long, and I would just sort of smile a little bit because I knew in most instances that the judge's calendar sort of coincided with ours. So that was very interesting. Subsequent to my time there, I went into private practice. I was fortunate enough to go with the prosecutor's office also as a deputy prosecutor. Invaluable experience in the prosecutor's office as far as I'm concerned. And also I was the attorney for the housing authority of the city of Evansville, which was very interesting. After a few years in practice, I had the opportunity to go on the bench. And during the time in my very young years, from time to time, Judge Benty and Judge Merrill would ask me if I would pro tem for them, sit in as judge. And I did, and I liked it. I liked it very much. And so lo and behold, in not too terribly long a time, a new Superior Court was created in Vandenberg County, and I was appointed judge of that court. I was 32 years old at the time, which was rather novel in those days. And as an aside, I remember the first time I attended a state judges meeting. It was not called the Judicial Conference at that time, but nonetheless, we had annual meetings. And I walked in to this social gathering, and it was like everything stopped. And I guess my age had preceded me or something. But anyway, it was astounding. I was a little perplexed. I thought, well, what do I do now? At any rate, when I first took the bench and when I started practicing, for lack of a better term, we were still practicing here under the old cause of action pleading. And it was very time consuming. At that time we had the circuit court, obviously, and the judge was Ollie Reeves. And at that time, circuit court was exclusively criminal court. I mean, you simply did not file civil cases in circuit court. In addition, we had Superior Court, Judge Benjamin Benty, and probate court. And when I first started practicing, French Clement was the judge of probate court. Shortly thereafter, Maury Merrill succeeded French as the judge of probate court. So all of the civil business was done in those two courts. To make matters even worse, the probate court at that time not only handled the probate work, but also was juvenile court. Handled all of the divorce business. And I think that came about over a period of time. That's just the way things had been done. And also, in some way, the civil cases were supposed to be sandwiched in between in that court. So I think when I was appointed, the very first thing I did, once the court was up and running, first of all, they had to find a new courtroom. So they went up to the third floor in the old courthouse and created a courtroom. That took some time. I was appointed in March the 11th of 1965, I believe. Court, we probably didn't get underway actually until maybe first part of April. I mean, they were hammering together a jury box and all kinds of things. So the very first thing I did, I went to Judge Merrill and said, Maury, if you would like, I will take half of your divorce calendar right now. Because, you know, we were a new court. And, well, he was gratified, obviously. Not so, however, the divorce bar, particularly the older lawyers, because they had a way of doing things. And I was familiar with that because during the time when I was a deputy prosecutor, one of my duties was to go over to probate court on divorce day, Fridays. Everything was on Friday. Represent the state of Indiana in default divorces, and also to see that that the residency requirement was met, and it was met in strange ways. So I was familiar with how that operated. And I'm sure the lawyers who practiced extensively, the older lawyers who practiced extensively in divorce court, liked that because they were familiar with it. So now they had to contend with two courts. I was hearing divorce cases, and that did not go over well for a while. But they came around and ultimately, I think, found that it was really to their benefit. So that was an interesting thing. If you have questions, Susan, interrupt.
You talked about the interesting ways they proved residency.
Yeah, well, it was not uncommon you had to have two residency witnesses, two people to say, yes, I know so-and-so, and he or she has been a resident of Vanderburgh County, blah, blah, blah. So more often than not, there was one residency witness, and then the lawyer would say, and Your Honor, I know Miss so-and-so, and I know she's been in. And we would wink and blink and nod at that, I think. But it was not that important. So at that time, some of the local practice was still under what it was what I call the old cause of action type pleading. Not with the specificity that was required in England hundreds of years ago, but nonetheless, you pled a cause of action, and you had to plead it specifically. Well, what that had given rise to was an interminable amount of time between the time that a case was filed and the case got to the trial calendar. And if I may, I'll explain the reason why. You would file a complaint, and I am the opposing lawyer, particularly the defense lawyer. And I speak of this from practice because I was with a defense firm. And most of my work was either defense work, divorce work, or prosecutorial work, or in the criminal field. Almost always I was always in court. That's where I wanted to be, in court. I would not have been a good office lawyer. In fact, I suspect that had I been shunted to or found that niche, I don't know whether I would have remained in the practice. Mm-hmm. I wanted to be in the courtroom. So you have filed your complaint, and I read your complaint, and automatically I file with the court a motion for a more definite statement. So that has to be filed and has to be set on the court's calendar. And in those days, you would go into open court in the morning, and there would be innumerable attorneys, and you would argue these motions in open court. And in the majority of instances, the motions meant nothing. So then you would get a ruling on that, and your motion would be overruled. Okay. So I'm going to file now a motion to make more specific. Same thing, more time. Then, if maybe, if the court overruled the motion to make more specific, I might file a motion to reconsider the court's ruling on that particular motion.
Wow.
So then we get past that hurdle. So we file a partial demurrer, saying this point and this point and this point and this point, and the complaint means nothing, and we demur to that, and we want that stricken. Okay. Well, so that's overruled. So then we file a general demurrer to the complaint in general. That's overruled, and then finally we get the case set for trial. It took a considerable amount of time, and I mean that's the way the preliminaries worked in cases during that period of time. So when I was appointed Superior Court judge in Superior Court number 2, and by the way, while we're talking about Superior Court number 2, it's a part of the legal history of this county, and it's overlooked, I think. You know, when we went to the Unified Court, obviously, Superior Court and Probate Court no longer existed. And I like to tell people that I was the very best judge in Superior Court 2 and the very worst judge in Superior Court 2 because I was the only judge in Superior Court 2. One of the next things I did when I had my own court, I sent a notice to the bar that arguments on motions would no longer be held in open court. That they would come to my office ahead of time, and when they filed the motion, we would put so many on the calendar for each day. They would show up at the appointed time. We didn't have to waste their time in the courtroom, and they didn't have to sit around. If they had to be in more than one place near the given time, they were more likely to be there that way than if they had to wait their turn in open court. And it didn't take long, and that took hold. And there were some other minor changes. As time went on, it became obvious as the business increased a little bit that to have circuit court, superior court, probate court, superior court number 2, and federal court on a rotating basis was going to become a bit much in terms of lawyers making the rounds and scheduling things in the various courts. So I was the young judge, and a couple of lawyers approached me and asked, had I heard of the unified court concept? I said, yes, I had. Would I be interested in discussing that? Certainly. A committee was formed. I'm trying to remember all of the people who were on the committee. We had trial lawyers. I made sure there were some divorce lawyers on it. Jack Vanstone, who I understand participated, was on the committee. And we discussed a myriad of things, you know. How would this court work, you know, and would we have asked for another judge? How would we set up divisions of the court? And would we rotate through the divisions? And if we had a unified court, what would we do about misdemeanor court and the justice of the peace courts? And I can't remember if at that time the justice of the peace courts had been eliminated. I think that either they had been eliminated or were going to be eliminated. So what would we do with those kinds of cases? So we talked about a small claims division.
What year was this, Judge?
Well, I'm trying to remember. The unified court, we're talking about the early 70s.
Okay.
This would have been shortly after we moved over into the new building.
So mid to late 60s.
Oh, well, or maybe even early 70, okay? So we realized that we were going to take on not only the jurisdiction that the 3 courts had, but we were also going to take on the additional jurisdiction of misdemeanor court and what would become small claims court. And that became a very extensive jurisdiction and required some thought about how things were going to be handled. Were we going to rotate through every division? Did that make sense? You know, maybe it would to begin with. Let's see what happened. We even did things like changing how certain papers were filed, and we color-coded them so that when you looked through a file, if you saw a blue paper, you knew it was this kind of pleading. Or if you were hunting for a specific thing, if you wanted to look at the summons, if you wanted to look for this, they were color-coded, you know, maybe blue, yellow, green, which made it a lot easier. So anyway, we met and met and met. I don't know really how else to say this. The other judges were older, and they were not quite as interested in this concept. And I understand why. I understand why. Because I'm one of the old fellows now. So anyway, those kinds of things were settled with a great deal of input from the lawyers. I was accepting of that from the beginning, and I had little problem convincing the others that it was probably the thing to do. And it was. It absolutely was.
How long did it take?
Oh my goodness. Now you're, well, it took, we had the proposed legislation. It went to the legislature, it was passed, and bang, there it was. There were some humorous things that happened, particularly with the older lawyers. And again, it's because, you know, when you're accustomed to doing things in a certain way, and particularly if you've been doing them for years and years and years, that's a little traumatic to change. But we got complaints like the older lawyers, or a lot of the lawyers, didn't like it because they didn't know which courtroom to be in. Well, the courtrooms were labeled. Our names were on the doors, but we initially made a mistake. What we were doing, first of all, Division 1 was a civil division. Division 2 was the criminal division. Division 3 was another civil division, and Division 4 was the domestic relations division. Small claims was separate. Misdemeanor and juvenile was separate. So, you know, the judges had a tendency, we were all down on the first floor, to use the courtroom opposite your office. Well, that meant that, take my office for example. When I was in Division 1, it was Division 1. When I was in Division 2, it would change, and Division 2 would be on the outside door. And the lawyers just had a terrible time figuring that out. And so we decided that was our mistake. So we decided that the first courtroom that you came to going down the hall was Division 2, and it would remain Division 2. And that was because the holding area for prisoners was, that was closest to the holding area. The next one was Division 1. The next one was a Division 1, and the next one was a Division 4. All of the criminal was at one end of the hall. All of the divorce was at the other end of the hall. And we rotated through those divisions. And for a while, we even rotated through juvenile division and misdemeanor court. But those being high volume courts, even in those days, nothing like today, but even in those days, rotating through didn't make a whole lot of sense. After a while, we saw that. It required really someone who was there on a day-to-day basis to handle those kinds of things, to become familiar with them. Small claims, yes, we rotated through small claims. So finally we decided we will have a judge in misdemeanor and we will have a judge in juvenile probate division. So after a while that worked out well. Prior to the time that the new courts building was erected, and we worked out of the old courthouse. And by the way, I liked the old courthouse very much. Funny story, my office was on the 3rd floor. And as you recall, Susan, the windows in the old courthouse are massive.
Mm-hmm.
I mean, what, 15 feet high maybe? Mm-hmm. And they had these heavy wooden blinds. And during the winter, I would sit in my office sometimes in my overcoat, and the big heavy blind would go. Those were the good old days. Mm-hmm. But there was very much about the old building that I liked. During those days, after the preliminary sessions of court in the morning, the lawyers would congregate almost every day at the old Maxwell House, which was directly opposite this building. Mm-hmm. that was very invaluable in many ways, and it was invaluable particularly for a young attorney who realized he didn't really know that much. There was a huge table that they had set up in the back, and all the lawyers congregated there. And they would discuss court happenings, and they would discuss, well, many things. Points of law, what was happening in the law. And I think some business was done there. And as a young lawyer, I mean, it was quite beneficial to keep your mouth shut and listen. And I did, and other young lawyers did. And in a way that was sort of like mentoring. The concept of mentoring, of course, we didn't have back in 1959, 60, 61. So there weren't specific mentors other than the people in the law firm that you work for. But in effect, the collegiality of the bar was such at that time that practically everyone was a mentor for young lawyers. I mean, you could ask anyone, you know, and they would help.
The more established attorneys were open to
Oh,
that.
yes, yeah, yes. And you got to know them well. And I remember, do you remember Charles Sparrenberger? Charles Sparrenberger, Fine, Hatfield, Sparrenberger, and Fine? He used to talk to me quite a bit. And you know, when I was brought up, if people were older than you said Mr. and Mrs. And I did when I came back as a young attorney. And I said Mr. Sparrenberger or whoever it was. Finally, he said, Terry, I enjoy talking to you, and I enjoy answering your questions if you have any. But if you don't stop calling me Mr. Sparrenberger and call me Charlie, that's going to cease. Very nice man, very nice man. And all of the lawyers were an adjunct to the Maxwell House coffee shop. When we went to the new building, of course, there was no Maxwell House coffee shop near it. So we thought, you know, maybe we need some place for the lawyers to congregate. And at that time, there were 4 courtrooms on the first floor and 4 jury rooms. So we decided that we could do with 3 jury rooms and turn part of the jury room and part of the last office at the far end, the Main Street, the North Main Street end, across from Division 4 into a lawyer's lounge. And there were 2 reasons for that. One, it was nice to have a place for the lawyers to congregate. And for, up until rather recently, maybe someone else should speak to this because I've moved to senior judgeship, and you know, I'm not down there every day, or near every day. But I mean, when we started that, the lawyer's lounge was always crowded. But there was another reason we did that, and that's so we would know where the lawyers were. And particularly since we had moved to the unified court, because if they weren't in a certain courtroom in a timely fashion, we knew where they were, and we'd send a bailiff to make sure that they got there. So it worked out quite well. We made a relatively major mistake in the rotation system, in the unified court system, in one respect. It was working extremely well, but in the civil jury trial division, the way we started out, we had a master calendar for civil jury trials because each of us was going to be in a jury trial division twice during the year. So the court administrator kept a master calendar of the cases that were on the jury trial list. And as we rotated through in each of our months, oh, by the way, I suppose I should tell you that we rotated courts on a monthly basis, which I liked very much because it kept you in different areas of the law, you know. We were all supposed to take, I can't remember, it was 25 or 30 jury trial cases every time we went through a jury division. Well, after a while it turned out that some folks were not doing that. And over a period of time, we discovered a very, very big backlog. And civil jury trial cases taken an inordinate amount of time to get them to trial. So we made a change, and we decided that the judge would keep jury trial cases, take them off the calendar and keep them. And it turned out that worked better. And even today, the system is being tweaked, and it always will be. There will always be room for change.
Judge, let me ask you, do you think mediation has changed?
Oh, yes, I was going to get to that. Yes.
Okay, well, I don't want to push you. I just...
You know, early on, and well, until the alternative dispute resolution legislation came down, cases were not mediated at all. I mean, someone might request formal arbitration, but that was a different animal altogether. Mediation, if it was done by the judge, quite frankly. You know, you'd hold like a pretrial conference. And some judges thought that the judge should not involve himself in attempting to resolve civil cases. I felt that a judge should involve himself in that, as long as he did not take sides in a case, and as long as the respective clients knew what was being discussed. But no, other alternative dispute resolution, absolutely not. The mediation that we have now is a fantastic tool because it gets rid of a lot of cases. And you know, and today it's used in all kinds of cases. Yeah. No one ever heard of mediation in domestic relations matters. Well, the lawyers would attempt to, in effect, mediate a case, resolve a case. Now, I don't know if this is true as I sit here today. Some of the judges, if not all, in certain instances, demand that the case be mediated before they'll schedule it for trial. And I have served as mediator from time to time since I became a senior judge. That I found did not turn out too well. And the reason being that more often than not, one side or the other was waiting, what should I do, Judge? What do you think, Judge? You know, and that's not the purpose of mediation. So I did not like that part of it. I got the feeling that simply because I was a judge, they were waiting for me to say, this is what should be done. And that's not the purpose of mediation. But yeah, well, you know, we have a number of lawyers who do extensive mediation today. And I think that's very good. You know, I think it was Abraham Lincoln that said, the best case is a settled case. And there is some truth there. Obviously, there are many instances when the case has to be tried. But generally, if you can have the parties become instrumental in resolving a conflict, you're much better off, because that's what lawyers and judges are dealing in. Lawyers in more recent times used to say, you know, I don't understand why sometimes the public general doesn't like lawyers. And I would say, my goodness, you know, you're dealing in human conflict. How do you expect these people who are involved in this conflict to embrace you? It just isn't done because that's just part of being a lawyer. There was something else I wanted to remark on. But you know, that old saying, you know why you shouldn't hang out with guys over 75 years old?
No. Why?
They can't remember names and things short term, and they always have to go to the toilet. Can we take a break for a second?
Sure.
There was some.
Judge, can you tell us what, if you had a case or two that you thought was very interesting that you'd like to share with us?
Yes. I've had many interesting cases, many complex cases, and many important cases. But there are two cases that stand out in my mind. One has to do with the jury in a civil case. I have always been a believer that juries most often arrive at the correct result. One may not know exactly how they got there, but more often than not, the jurors do, and I trust juries. I've heard other lawyers say, I wouldn't want to put my life in the hands of a jury. Well, I would. And the one case was very, very unusual. These two young girls were riding on a horse on a county road, and I think it was in Warwick County. A car came up, they were maybe over the crest of the hill, and a car came up from behind, didn't see them, hit the horse. One of the girls flew off and was uninjured. The other girl flew off, and a lawsuit subsequently was filed, and it wended its way to Vanderburgh County. And I don't know if I was special judge or that doesn't matter. And a complaint was filed. And in the complaint it was stated that as a result of the impact, the girl was thrown backwards from the house, struck her head on the windshield of the car, and as a result acquired a certain form of epilepsy. So we proceeded with the trial, and as I recall, there were at least 2 or 3 expert medical witnesses who testified in the girl's behalf to the effect that yes, as a result of this particular trauma, they felt that she had acquired some type of epilepsy. The plaintiff rested its case, and the only witness put on by the defense was one medical doctor from Louisville who was an expert in epilepsy. And as a matter of fact, he could not appear in person. I don't recall, it was a legitimate reason. He could not appear. So, and they took his deposition. So the lawyer, defense lawyer trying the case, put an associate in the witness box. You know how that works, Susan. He reads the doctor's answers to the deposition. The deposition is read to the jury. The doctor is not present, you know. This deposition took almost an hour and 15 or 20 minutes to read, maybe a little longer. And that's the only evidence that the defendant proffered. And this doctor said to the contrary. This girl could not have acquired epilepsy as a result of this trauma, and went into all of the medical reasons why. It was very involved and took a great deal of time. And so after final arguments, you know, the case was given to the jury and they retired. And they were in the jury room, I suppose, I don't really know. Doesn't matter really, but several hours. And they came out, and on the strength of that deposition testimony, found in favor of the defendant. I thought that was very, very unusual. And I gave that jury really high marks in terms of really being involved with the case, being attentive, understanding the issues involved. That to me was remarkable on the part of the jury. I don't know if you agree or not. That was one of the cases. The other, I think of this next case as a criminal case. Quite often, and particularly if I have been with folks outside the legal profession who for one reason or other like to watch lawyer shows on TV, and, you know, and they think, boy, this court stuff is really exciting.
Hmm.
And the truth of the matter is, except for lawyers, but for lawyers, most cases are really pretty boring. They're not like Perry Mason, you know. So this happened to be a case where the guy was charged with armed robbery, and he robbed a fast food place out on Washington Avenue. During the course of the trial, the prosecutor's office called as a witness one of the young ladies who happened to work at this establishment. Took her through the hoops and said, you know, where were you? Well, I was here. And what happened? She told him what happened. And, can you identify the man who robbed your establishment on that occasion? Oh, yes, I can. And is he in the courtroom? Yes, he is. He's the man seated right at that counsel table in the blue shirt. Thank you, ma'am. Cross-examination. Young lady, where were you at the time this allegedly occurred? She said, well, I was inside the store. And he said, well, tell us again what happened. She said, well, the person came in and he pulled out a gun and he said, everybody on the floor. And he robbed the store. And the defense attorney said, well, what did you do when he said everybody on the floor? She said, well, certainly I got down on the floor immediately. He said, well, just tell the jury, how much time elapsed before you went to the floor? Do you have any idea? And she said, well, goodness, it couldn't have been long. you 2, 3, 4 seconds. And he said, 2, 3, 4 seconds. And here comes a man in the store, and he's brandishing a weapon, and he shouts down on the floor, you comply, and yet you say you can identify this man? You can, she said, yes. And he said, well, how could you identify him? And she turned to me and said, Your Honor, do I have to answer that question? And I said, yes, young lady, you do. It's a legitimate question. And the attorney said, would you like for me to repeat the question? And she said, no. You asked me how could I be sure that this was the man who robbed our store? He said, yes. And she says, because he's the same person that robbed us once before. Honest to God, truth. Well, the jury broke up. And I had a trick when I sat on the bench. Funny things happened in a courtroom. I always kept a pencil, number 2 pencil, handy. And when something like that happened, I would grab that and clench it between my teeth.
They have a lot of bite marks that day on that pencil.
I went through a lot of pencils, yeah. But that has always stuck in my mind because in my career of 50 years, that's the closest I ever got to a TV type case in court. So I always do remember that. And as a matter of fact, I enjoy relating that to people. Of course, now as, well, let's see, I was a regularly sitting judge for 33 years. And then I have been a senior judge for 10 years. So more than half of my entire life has been spent on the bench. And I really didn't think about that until I decided that I was going to retire from the regular bench. And I made a point of mentioning that in the courtroom for the ceremony that we had. Because I really had not thought about that. And we were at a meeting with some of the Supreme Court judges, and Judge Shepard at the time pointed out that I had been on the bench at that time 25 years. And that had not dawned on me. And it seemed to have dawned on everyone else. Maybe they wanted to get rid of me. So I thought about that. I thought, why didn't that dawn on you? I mean, it's not an insignificant thing. And I came to the conclusion, and this is what I told those judges at that meeting. I said, after some thought, I think that I felt that what I was doing was so important, and I enjoyed it so much that time didn't mean anything to me. The time on the bench just never entered my mind. And I've thought about it again. And I think that's true for me. Now, whether it's true for other people, I really don't know.
Is there one thing that you could name that made you feel that way? The public thinks in terms of dispensing justice. Is there one thing that is it teaching the young lawyers? Is it?
Well, it's part of a lot of things, but I think it's the attempt to ensure that every litigant does receive a fair and impartial trial. And let's face it, you know, the judge controls that. I also always thought, and by the way, this is another change, a recent change that we made that was for the good. Prospective jurors are better educated before they hear a case now than they used to be. But I always felt that it was important to make jurors feel that they were not only an integral part of a case, but that once the trial began, they were the most important people in the courtroom. And I would go out of my way to try to do that. I also found that the judge sets the tenor in his courtroom. I never raised my voice in the courtroom, nor did the lawyers in my courtroom. And that's because once you set that tone, and once they understand that that's the way they're supposed to do, that's what happens. Mm-hmm. If you become argumentative, or if you allow the attorneys to become argumentative, that can destroy the tenor in the courtroom. You know, this is what I feel. You know, I see what the few times that I see dramas on TV involving the courtroom, and when I watch these terrible TV judges on these, what are those shows? Judge Judy and all that stuff, you know. If judges acted that way in the courtroom in this state, they would be disciplined, and rightfully so. You do not talk to people that way. And if you can avoid it, you keep upper in your mind that you never ever talk down to people. And you adjust your language to the appropriate language with whomever you're speaking. And those things don't happen, you know, on those kinds of shows. And as a result, I really do think that that's an injustice to the judicial system in this country. I just hate the idea of those shows being on television. But again, that's my perspective. I'm sure others feel differently.
Not too many, I don't think.
And they seem to be multiplying. I don't know.
Absolutely. Let me ask you one final question. We can close out with this. If there's one person that you'd like to hear their story, living or dead, who would you like for it to be?
Oh, my goodness. You know, there were so many older attorneys, at least older attorneys when I got here, that I found so interesting. Of course, the bar was more interesting in many ways back then. You know, I hate to single out one person because there were so many that I liked and admired. I'm thinking of, you know, of some of the more colorful, older attorneys. Going back to old Judge Gould. Do you remember Phil Gould? No. Oh, okay. Mr. Welborn. I still call him Mr. Welborn. And some of the old lawyers. You know, like Marion Rice and Ole Olson and Wilbur Dassel and Lauren Kiley and some of the real, I mean, these were folks that were not young when I got on the bench. And they were all unique, and they were very colorful. There was I don't. Marion Rice was an extremely colorful man. And he was a bright man. He was combative at times. He didn't shy away from a courtroom fight or any kind of fight. But if I'm not mistaken, I hope I'm not mistaken. I wish I had been here earlier. You said Jack Vanstone was here. I would have asked Jack. Marion Rice may have been one of the last attorneys who practiced here without benefit of having gone to law school.
That is correct. I have heard that before,
Yes,
and that is correct.
I think that's true, and I think he mentioned that to me once. And for him to have kept up on the law the way he did, practice the way he did, be as knowledgeable as the way he was, without having done that, but just having apprenticed, I suppose,
That's what he did.
in a legal office, he really was a marvel. He really was a marvel. And I always respected him for that. And I have a funny story about Marion Rice. May I?
Yeah, absolutely.
Of course, Marion knew me when I was this high. Because years ago my dad was sheriff, county clerk and sheriff, and a lot of the old lawyers knew me. I used to run around the old courthouse. So Marion knew me. And we were in court one day, and Marion's opponent was a young lawyer. And he had made some type of argument in court, and he had made some comment. And Marion said, you know, young man, I don't know what kind of law books you read, but the judge, he and I read the same law books. And when he was saying that, he had his back turned to the audience, and he was looking at me. And when he looked at me, he winked. I couldn't let that go by, and I said, well, now, wait a minute, Mr. Rice. I said, I read those black books with the gold letters. Which books do you read? But that's the kind of guy Marion was. Always colorful. But I'll tell you this. He was a formidable adversary. And there were many others like him. Many others. And before, when I talked about mentoring, you know, the collegiality at the bar during my early days, I mean, was just phenomenal, you know. For example, I still call him Mr. Welborn, old Bill Welborn. Was an elderly man when and he practiced right here in the court building. Mm-hmm. And for some reason or other, don't ask me why, he sort of took a liking to me. And he would invite me to dinner or lunch down at the old lamplight. Do you remember the old lamplight?
Of course.
And he would, in his own way, take the time to educate me in many ways. I was really, really appreciative of that. And another aside, at that time, the owner of the lamplight was the father of now senior judge Bill Stevens.
Who is coming in next?
Mm-hmm.
Interesting.
Yeah.
Interesting.
So I'm sure there's a lot that has been left out, and you know, we could probably go on for another hour. But I hope at least that this was helpful.
It was wonderful. Thank you very much, Judge. Appreciate you coming in.
You're quite welcome.
Are we done?